what every Social Security disability applicant needs to know about steps 4 and 5 of the 5-step sequential evaluation. If your coronary artery disease doesn't meet a listing, you will have to meet the medical and vocational criteria at steps 4 and 5. At step 4, you have to show that you can't go back to the lightest job you held in the 15 years before you became disabled because of your residual functional capacity. And at step 5, that there isn't any other work that you can do in the mythical national economy in view of your age, education, skills, and that residual functional capacity. Well, what is a residual functional capacity? It's what you can do despite your coronary artery disease. Many times when people apply for benefits, they just don't have the medical documentation there that's needed. The Social Security Administration is going to look for 3 months of medical records documenting the clinical course of your coronary artery disease. Those records should include your history, physical exam findings, laboratory tests, treatment, the results of ECGs, and exercise tolerance testing. Why is all of that important? Because the Social Security Administration will try to determine your functional capacity. Can you do sedentary work, light work, medium work, or heavy work? If they can't tell from your medical records, or your doctor hasn't commented, the Social Security Administration is going to send your whole file to a medical consultant. And guess what? That consultant will render an opinion that you can go back to work at some level that will allow the Social Security Administration to deny your claim. You need a residual functional capacity form completed by your doctor. Now, the Social Security Administration won't tell you about the existence and importance of a properly completed coronary artery disease residual functional capacity form, but I have. That form is crucial because it will explain how your chest pain, your shortness of breath, or your fatigue impacts your ability to walk, how long you can stand and sit at one time, how long you can stand and sit in an 8-hour day, how much and how often you can lift, stoop, squat, and bend during an 8-hour day, whether you've got to take a nap because of fatigue, or you have to break up chores because you just don't have the energy to finish them, whether you have side effects of medication like headaches, dizziness, nauseousness, vomiting, whether you've got to use the restroom frequently, whether you've got to elevate your legs, and if so, for how long and how often, whether you have difficulty concentrating, whether you have difficulty starting something and then staying on task and finishing it, whether you have good days or bad days, how many days per month you'd miss from work, and whether you have emotional problems that result because of your cardiac problems in depression or anxiety. This is not a complete laundry list of all the questions your doctor should address, but hopefully you now understand why it's important to have this information so that the Social Security Administration can determine physically, cognitively, and emotionally what it is you can do. Now that's just half of the equation. The other half are the vocational issues that are at steps 4 and 5. If the Social Security Administration can't figure out your residual functional capacity, they won't be able to figure out the right answer to steps 4 and 5. If you aren't represented by an attorney, it will be difficult for you to get your benefits. In fact, 2/3 of the time, claims are denied at the initial application stage. And I think that's because the applicant didn't do a bang-up job in describing their physical duties and cognitive duties, and they didn't have a residual functional capacity form. And that means they have to file a request for reconsideration. And guess what? 2/3 of people make the same mistakes that they've made the first go around. That means you'll only have 60 days in which to file a request for a hearing in front of a judge. You heard the word judge. That means a trial. And if you're at a trial, the judge will be the one who will determine your residual functional capacity, and they will be the one to give a hypothetical to the vocational evaluator who will be testifying at your hearing. The judge will ask the vocational evaluator to take into consideration your residual functional capacity form and answer those 2 questions, steps 4 and steps 5. So let's say that the judge says, Mr. or Mrs. VE, I want you to assume that this mythical hypothetical person, just like this person in the courtroom, can sit for 6 hours, stand for 6 hours, lift 10 pounds. Can that person go back to the lightest job they held in the 15 years before they became disabled? Now that is a crappy question, because that question is designed to get the vocational evaluator to say, oh yes, and that means the judge will deny your claim. If the judge doesn't add anything to that hypothetical, like I want you to assume they have to take naps twice a day for 30 minutes, have to elevate their feet every hour for 15 minutes, you're going to lose your claim. If the judge doesn't ask that ultimate question of whether there's other work in the national economy that you could do, you're going to lose. And if that VE answers that question by saying, you know, Judge, they could put silverware in a cloth napkin and roll it up. They could fold laundry in a laundromat. They could address envelopes. They could do light assembly work. You're going to lose your case. Hopefully you understand now why it's crucial that you have an attorney represent you at every stage of the case, to help you with that initial application, to help you with a request for reconsideration, and to help you get ready for a hearing. Look, you don't know the 5-step sequential evaluation. You don't know what's in your medical records. You don't know how to get a winning residual functional capacity form. You don't know how to testify, and you certainly don't know how to cross-examine a vocational evaluator. The odds of you getting your benefits are greater when you're represented by an experienced Social Security disability attorney. Why would you want to jeopardize your Social Security disability money benefits and your medical because you think you can do it yourself, or you're hoping that the judge will feel sorry for yourself? That just doesn't work. If your claim has been denied, call me today at 727-894-3188 for a complimentary consultation.